Hello and welcome to Byju's Exam Prep IAS. Welcome to the big news. The topic for today's discussion, Kyoto Holohan judgment. Let us try and understand what is this judgment all about. What is the brief gist of this judgment? Kyoto Holohan Zachilu and others is a landmark judgment delivered by the Supreme Court which upheld the sweeping discretion available to the speaker in deciding cases of disqualification of the MLAs. So this judgment is directly linked to the anti-defection law. This can also be asked in your preliminary examination as well, where they might give you a case law and they might ask you what is it in reference to. So remember, Kyoto Holohan is in reference to the anti-defection law. What did the Supreme Court say with respect to this particular case? What is this case law all about? We know for the fact that the 10th schedule of the Indian Constitution deals with the anti-defection law. What is this anti-defection law? Let's say a person who belongs to one political party moves to another political party. So if a person moves from one political party to another, that person will be disqualified, and all of this is covered under the 10th schedule, the anti-defection law. Let's look into important paragraphs from the anti-defection law. What does it say? Paragraph 2 of the 10th schedule says that a member of the house belonging to any political party shall be disqualified from being a member of the house if he has voluntarily given up his membership of such political party. So if this person who is elected on a party ticket happens to leave this party and happens to switch his allegiance to another party, in that case he has voluntarily given up his relationship with that political party from which he initially contested, and such person can be disqualified, says the 10th schedule, that is the anti-defection law. Added to it, if he votes or abstains from voting contrary to any direction issued by the political party without obtaining prior permission, such person can also be disqualified as well. What do we mean by it? We have something called as the party whip, which is appointed by every political party. This party whip will ensure that the progress of that political party in the house, whether it is in the assembly or it is in the parliament as well. So this whip of the political party will ask its political party members to conduct their affairs in a particular way. So let's say there is introduction of a bill. So when there is introduction of the bill, the MLA or an MP will be advised to vote in a specific direction, whether they should vote or they should not vote, whether they should vote or abstain from voting. All of this will be given by the party whip. But contrary to this direction, if an MLA or the member of the parliament votes, in such a case, he means he is violating the party rules and regulations. He is going against the party whip. In such case as well, this person can be disqualified. So there are two parameters. One is voluntarily giving up his membership from that political party, switching his allegiance to another political party, and at the same time he's been asked to vote or not to vote in a particular direction, but he continues to vote contrary to the issuance of the whip of that political party. In this particular case, this person in all likelihood can get disqualified according to the 10th schedule, and that is the anti-defection law. What does paragraph 6 say? Paragraph 6 says that it describes the speaker's sweeping discretionary powers. If any question arises as to whether a member of a house has become subject to disqualification under this schedule, the question shall be referred to the decision of the chairman in the Rajya Sabha, as the case may be, the speaker of such house, or the decision shall be final. So if it is in the Rajya Sabha, it will be the chairman. If it is in the assembly, it will be the speaker. If it is in the Lok Sabha, it will be the speaker. So it is these people who will decide whether that person has to be disqualified or not. And in this particular parameter, whatever decision that they make will be final as well. But do remember that if a person has to be disqualified, there has to be a petition or a notification that has to be given by the other members. So other members will have to bring a notice in front of the speaker, or it can be the chairman in the Rajya Sabha. But if it is legislative assembly or the Lok Sabha, they have to bring it right in front of the speaker. The speaker will not take it suo moto, but other members will have to bring it to the notice of the speaker. So the speaker ultimately decides whether this person has to be qualified or he has to be disqualified, and his decision will be final as well. So what is this judgment all about? This is a judgment that was given by the Supreme Court of India. So the Supreme Court of India was asked two important questions. When we speak about the speaker, who is a speaker? He is from the political party which is currently governing. So whichever party is formed the government, the speaker will be from that particular party. So if the speaker is elected from that political party, he might also have an inclination of political bias as well. If he has the political bias, how can he give impartial judgment? So this was a question asked to the Supreme Court of India. So Supreme Court was asked, should this power be given to the speaker or should there be a larger body, was one question. The second question was with respect to the judicial review. If you look into the last statement, it says speaker of such house and his decision can be final. So does this mean the Supreme Court or the High Court will not have any review power? This was another question that was asked. So basically two important questions were asked. One, can this person be alone deciding this disqualification method? Another question is, if he so decides, can the judiciary not look into it? So the Supreme Court looks into both these questions and ultimately delivers the landmark judgment in the Kyoto Holohan case. What did the Supreme Court say? The first question that it answered was with respect to the judicial review. What did the Supreme Court say? The Supreme Court said that judicial review is part of the basic structure. We have the basic structure which is the judicial review is part of this basic structure. So if judiciary is omitted, it violates the basic structure. So what we the Supreme Court say is that if there is a decision that is given by the speaker or by the chairman of the Rajya Sabha, and if it is violating some of the very intrigued questions, in that case judicial review cannot be taken up. We will take up this particular issue, we will look into it, and this particular decision, that is the judicial review of the Supreme Court, will only happen after the speaker has given his own judgment. So until the speaker gives the judgment, we will not interfere whatsoever. If there is a person who has an apprehension that the speaker may disqualify, even then we will not interfere as well. Only when the speaker passes his judgment, then if there is something wrong with that particular judgment with respect to the disqualification, that is when the Supreme Court will immediately step in. So what did the Supreme Court say? The Supreme Court said that yes, the judiciary has the powers of judicial review. It can look into this particular order passed by the speaker with respect to the disqualification. We will not interfere till the speaker passes his order, but once he does so, we have every right to do so, says the Supreme Court of India. So the Supreme Court in this landmark judgment clearly went on to say that the constitutional courts cannot judicially review disqualification proceedings under the 10th schedule of the Constitution until the speaker or the chairman makes a final decision on the merits. So once he makes the final decision on the merits of this case, we can step in because judicial review is part of the basic structure, says the Supreme Court of India. Originally, the Act provided that the decision of the presiding officer is final and cannot be questioned in any court. However, in Kyoto Holohan case, the Supreme Court declared that this provision as unconstitutional on the grounds that it seeks to take away the jurisdiction of the Supreme Court and the High Court. It held that the presiding officer, while deciding a question under this 10th schedule, function as a tribunal, and hence his decision, like any other tribunal, is subject to judicial review. So we have the power to review this decision, said the Supreme Court of India. Added to it, there was another question asked as well, that is to do with the speaker's power. So the speaker can have the political biasness as well. He cannot be impartial as well. Whatever decision that he gives with respect to disqualification may not be right. So the Supreme Court in this particular case also goes on to say that yes, we do have the judicial powers, but that does not mean we are snatching away this particular power from the speaker. So the Supreme Court went on to say that under this anti-defection law, which is mentioned in the 10th schedule, the right person to give the judgment with respect to the proceedings of the disqualification is ultimately given to the speaker. We do hold by it, and the speaker will continue to pass his own order with respect to the disqualification. So in the assembly, it will be the speaker. In the Lok Sabha, it will be the speaker. In the Rajya Sabha, it will be the chairman. They will decide and we will not interfere here, says the Supreme Court of India. In the majority judgment authored by Justice M. N. Venkatachalaya, And K. Jayachandra Reddy answered this question in an affirmative, where they said the speakers or the chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and take far reaching decisions in the parliamentary democracy, vestige of power to adjudicate questions under the 10th schedule in them should not be considered exceptional, which means that they would be given this power and this power continues to remain with them, and in the near future as well they are the ones who will pass the order and that will be held final. But what we will also have is judicial review is part of the basic structure, so we can review such decisions, says the Supreme Court of India. When you speak about this particular judgment, you had 5 members who gave this judgment. 3 members were in favor of the speaker passing this judgment, but there were other 2 who were not happy with it as well. So Justices Lalit Mohan Sharma and J.S. Verma dissented and took a different view. They said the tenure of the speaker, who is the authority in the 10th schedule to decide this dispute, is dependent on the continuous support of the majority in the House, and therefore he does not satisfy the requirement of such an independent adjudicatory authority. They also added an independent adjudicatory machinery for resolving disputes relating to the competence of members of the House is envisaged as an attribute of the democratic system, which is the basic feature of our constitution. The speaker's choice as the sole arbiter in the matter violates the essential attribute of the basic structure, say the other 2 judges who were against it. So the minority judgment clearly goes on to say that this person, the speaker, because he has the support of the majority political party, because he represents the voice of the party which is currently governing it, he may not be able to provide right order or pass right judgment when it comes to the disqualification procedure. Instead, what we require is an independent adjudicatory authority which has to be named for this particular procedure. So this was the judgment given by the Supreme Court of India in the Kyoto Holohan case. Now the question is, when you consider the state of Maharashtra, where there is a lot of political crisis, we do not have the speaker as of now. So if the speaker is not there, what is an alternative? The alternative to this would be the deputy speaker. If you look into the Constitution of India, we have Article 93 of the Constitution, which mentions the position of the speaker and deputy speaker of the House of the People. And then if you look into Article 178, it contains the corresponding position to speaker and deputy speaker of the Legislative Assembly of the state. So in case there is no speaker, it also means we have the deputy speaker. And we also know from Article 95 of 1, while the office of the speaker is vacant, the duties of the office shall be performed by the deputy speaker. If the speaker's office is not present, we have the deputy speaker. The deputy speaker will be performing all these operations. So it means that the deputy speaker can take up this particular proceedings and he can go ahead and pass his judgment with respect to the disqualification. So if speaker is not present, the deputy speaker who is daunting that particular position, who is conducting the proceedings of the House, he would be able to pass an order, and ultimately whether people should be disqualified or not will be decided by the deputy speaker. So if no speaker, then deputy speaker will be in charge for the proceedings of the disqualification under the 10th schedule. It is this that we have to understand with respect to this issue. So this is it for today. Thank you for watching. All the best.